Good afternoon. We are continuing the Section 59 investigation. We have Advocate Ngcukaitobi of SC, who is an expert in many areas of the law, and including the Constitution itself. He is going to be taking us through the legal implications of what has been referred to as racial profiling. Mr. Ngcukaitobi, I see that you have been multiplied 3 times. No, yeah, I suppose.
You'll need to put your mic on, Mr. Ngcukaitobi.
All right. So you've been called as an expert, so no point in swearing you in. So just take us through your presentation.
Chair, may I hand up extracts from the Constitution, the Equality Act, and 2 cases to which I shall refer. And let me perhaps just frame what it is that I'm going to address to make it clear that it's a very limited topic, as I understand it. I will speak only about unfair discrimination on the grounds of race, and then in doing so deal particularly with 2 sub-questions, and the one is the difference between direct and indirect discrimination, and secondly, the relevance and role of intention in assessing discrimination. Now, discrimination may be committed by a law or by conduct, and I am not au fait with the intricacies of your inquiry, but I will take the example of conduct because it might be of closer relevance to you. Let's call it a policy. The question is whether any particular policy constitutes unfair discrimination. And the way in which I propose to approach it is firstly to look at the Constitution, what it says about unfair race discrimination. Then to look at 2 of the leading cases which have created the framework for the regulation of unfair race discrimination. And then in the light of that background, the Constitution and the cases, to look at the Equality Act to see how it addresses unfair race discrimination. So what I'll do is to start then with the Constitution. I gave you a copy of an extract from the Constitution, and I merely point to the following provisions. A good starting point is perhaps Section 1B, because it makes it clear that non-racialism is a founding value of our society and our Constitution, and it is in the light of that elevated importance of that value that the inquiry into unfair race discrimination should be approached. Then there is Section 8, which is of marginal relevance, and particularly Section 8.2, which makes it clear that although the Constitution generally applies to the state, some of its provisions may also apply to private individuals, so that in the context of an inquiry such as this, the Constitution may, in certain circumstances, apply directly to healthcare funders. We get then to the really important section, Section 9, the equality section. And as I said, I'm going to focus on unfair race discrimination. And I'm not going to deal with equality generally. But it is of some relevance to start with the first and second subsections of Section 9, which deal with the right of equality. One says, everyone is equal before the law and has the right to equal protection and benefit of the law. 2 says, equality includes the full and equal enjoyment of all rights and freedoms. To promote the achievement of equality, legislative and other measures designed to protect or advance persons or categories of persons disadvantaged by unfair discrimination may be taken. For our purposes, the relevance of these equality provisions is that they make it clear that what the Constitution guarantees is substantive equality, not mere formal equality. So we look at substance, we look at reality, we look at impact, and not mere words. There is then two provisions that prohibit unfair discrimination, 3 and 4. The first applies to the state, and the second to everybody else. So we'll be in the everybody else category, that's 4, but let me, by way of background, start with 3 and point out that it is a prohibition upon the state which says it may not unfairly discriminate directly or indirectly against anyone on one or more grounds, including race. So and then a number of other grounds are mentioned. So race is one of the specified grounds of discrimination which is prohibited. And in this provision, the one that applies to the state, unfair discrimination is prohibited not only on the specified grounds, but also on the specified grounds. So it is not a closed category of prohibited grounds. You then get to the one that's directly relevant to us, and that's sub 4. It applies to everybody, including healthcare providers. It says, no person may unfairly discriminate directly or indirectly. There is again that phrase which speaks directly to one of the questions of my brief. No person may unfairly discriminate directly or indirectly against anyone on one or more grounds in terms of subsection 3. National legislation must be enacted to prevent or prohibit unfair discrimination. So in this case, this applies to everybody, not only against the state. The prohibition is also one of direct or indirect discrimination, and it is confined to the enumerated or the specified ground, no longer including. So it is a closed list of grounds upon which there may be no discrimination. And then the last provision of Section 9 is sub 5, which is relevant to our inquiry, and it says, discrimination on one or more of the grounds listed in subsection 3 is unfair unless it is established that the discrimination is fair. In other words, once there is discrimination on a specified ground, then the discrimination is presumed to be unfair unless the perpetrator discharges the onus of proving that it is not. So much then for the Constitution. If I may then go to the two cases which I have said created the structure under which these provisions are applied. The first is Harksen's case. That's Harksen v. Lane, 1998, Volume 1 SA, page 300, a judgment of the Constitutional Court, in which it analyzed the equality provisions in Section 8 of the interim Constitution. But you can accept that this case and what it said about equality under the interim Constitution are equally applicable to the final Constitution for two reasons. The first is that the Constitutional Court has said so on a number of times. So we have it on the highest authority that this is still the authoritative analysis of the equality provision, not only under the interim Constitution, but also under the final Constitution. And the second is that you will see that the final Constitution has in fact adopted its formulation with the Harksen structure in mind, reinforcing the Constitutional Court's finding that Harksen is still good law. And what Harksen did was to analyze the method by which one determines whether in any particular case unfair discrimination has been committed. It does so from paragraph 43, but then after an exhaustive analysis, summarizes its conclusions in paragraph 54. And if I may just read a few of the crucial snatches of paragraph 54, because they are ultimately the structure that we are concerned with. Paragraph 54 says the following: at the cost of repetition, it may as well be to tabulate the stages of inquiry which become necessary where an attack is made on a provision in reliance on Section 8 of the Interim Constitution. They are: 1. Does the provision differentiate between people or categories of people? That's the first question, and I'll come back to it. In B, does the differentiation amount to unfair discrimination? This requires a two-stage analysis. Firstly, does the differentiation amount to discrimination? If it is on a specified ground, then discrimination will have been established. And then sub 2, if the differentiation amounts to discrimination, does it amount to unfair discrimination? If it has been found to be on a specified ground, then unfairness will be presumed. If it is on an unspecified ground, well, I don't need to read the rest. We're dealing with race discrimination, which is a specified ground. So this is actually a very simple structure, if I may reduce it to its essential steps in an inquiry whether a policy constitutes unfair race discrimination. The first question is, does it differentiate against people? And to determine differentiation, one looks at its impact, not its language. The question is not merely, is it on its face? Does it on its face differentiate? You ask, because we're concerned with substance and not words, you ask yourself, does it disproportionately impact on some people rather than others? So that's the first question, does it differentiate? If it does, the second question is, does it differentiate along the lines of race? Because that would then be differentiation on the grounds of race. You see where the line of differentiation lies, and you ask yourself, is it race? In other words, does it impact disproportionately on one race rather than the other? If the answer is then yes, then the third step comes in. The yes answer triggers two consequences. The first is that the differentiation is now classified as discrimination. There's no further inquiry. Differentiation along the lines of race constitutes discrimination. But it doesn't yet constitute unfair discrimination. The second consequence of the conclusion that there is differentiation along racial lines is that it is presumed to be unfair. But that presumption is not conclusive. In fact, it is often really the beginning of the real substantive inquiry into the fairness of the differentiation. And let me give perhaps a trite example just to make the point that the inquiry often starts at the unfairness inquiry rather than ends at the ends at the presumption of unfairness. Take, for instance, the law that criminalizes robbery, and assume that 99% of people caught and prosecuted and jailed for robbery are men. Then you would have a differentiation on the grounds of gender, that's on an enumerated ground, and for that reason it constitutes discrimination and is presumed to be unfair. But the unfairness inquiry will immediately tell you, this is an easy unfairness inquiry, there's nothing unfair about it. Men commit robbery more often than women, and it is not, because the law is biased, it is simply because as a social phenomenon, men commit robbery more often than women. There are more difficult issues. One of the issues that have arisen in our law, where I think the Constitutional Court might have gone wrong, is on the question of whether the criminal prohibition of sex work discriminates against women. The fact of the matter is that the people who are arrested and prosecuted and jailed for sex work are more often than not women rather than men. The Constitutional Court said that that was for other reasons than gender, and for that reason did not find it to be unfair. So I think what I'm saying is that in our inquiry, is there differentiation? Is it on the grounds of race? If so, it constitutes discrimination, and the remaining inquiry is one into fairness. It seems to me that in your case, the analysis is a pretty easy one, up to the point where you get to the fairness inquiry. So I don't profess to know anything about the practice of healthcare providers. But on my limited understanding, for instance, they employ an algorithm to identify suspect service providers. If that algorithm disproportionately points a finger at black doctors rather than white doctors, then that would be a differentiation on the grounds of race, which constitutes discrimination and which opens the unfairness inquiry. And in that inquiry, the people who implement and practice that policy would bear the onus of proving fairness. And let me just say then, as far as fairness is concerned, that's the most difficult part of the inquiry. What the Constitutional Court said in Harksen, you'll see there in their paragraph 54B2, the last sentence. It says the test of unfairness focuses primarily on the impact of the discrimination on the complainant and others in his or her situation. So the focus of the unfairness inquiry is to look at the adverse impact on the victim and to ask yourself, in all the circumstances, is that disproportionate impact unfair? The Constitutional Court elaborated on the unfairness inquiry in paragraph 52, so you can put a cross-reference there at sub 2 to paragraph 52, and I'm not going to go there, but you'll see it remains, at the end of the day, a very difficult inquiry in many cases, because the Constitutional Court does know better than to tell us that there is a range of factors that one takes into account. But it does remain, at the end of the day, a value judgment that you need to make, in which you weigh up justification, the purpose of the policy, against the impact on the victims. You ask yourself, isn't there a better way of doing it to avoid the impact? And if the impact can't be avoided, you say, well, is it fair that the victims of this differentiation, of this discrimination, should bear that unfair impact? The second case to which I'd like to refer, because it addresses the two specific questions you've asked me to look at, is the case of Pretoria City Council versus Walker, 1998, Volume 2, SA 363, Constitutional Court. And it was an interesting case because what happened there was that Mr. Walker, a white inhabitant of Pretoria, complained that the municipality discriminated against him in favor of the black Pretoria citizens. What the City Council had did was the City Council had a diverse water provision policy, mostly born of our history. In white Pretoria, people were individually billed, and if they didn't pay, they were generally prosecuted for not paying. In Mamelodi and Atteridgeville, two of the traditional townships in Pretoria, a different policy was followed. The policy there was to charge everybody a flat rate, and Mr. Walker complained that that flat rate was cheaper than the price at which, the rate at which he was billed. And secondly, the municipality generally didn't prosecute people who didn't pay. So Mr. Walker complained, when Mr. Walker was sued for not paying his bills, he said, but the system is unconstitutional and therefore he shouldn't be prosecuted. The Constitutional Court then entered into the first inquiry, and that is there discrimination on the grounds of race? And that gave rise to two different questions. The first is the fact that the policy of the City Council said nothing about race. It spoke, if I may paraphrase it, it spoke of Old Pretoria and it spoke of Atteridgeville and Mamelodi. There was no mention of race in the policy they applied. But the Constitutional Court said that that is irrelevant because we look at impact, not language. The question is not whether the law is racially discriminatory on its face. The question is whether it impacts disproportionately. And if you would go in the Walker extract at paragraph 31, you'll see that that is where they deal with this question. The court said in paragraph 31, the inclusion of both direct and indirect discrimination within the ambit of the prohibition imposed by Section 8.2 evinces a concern for the consequences rather than the form of conduct. It recognizes that conduct which may appear to be neutral and non-discriminatory may nonetheless result in discrimination, and if it does, that it falls within the purview of Section 8.2. And then in paragraph 32, if I could skip to the middle, to a sentence that starts right on the right-hand side with the word the. The fact that differential treatment was made applicable to geographical areas rather than to persons of a particular race may mean that the discrimination was not direct, but it does not, in my view, alter the fact that the circumstances of the present case, it constitutes discrimination, albeit indirect, on the grounds of race. Reinforcing the point again that we look at substance, not form, and you ask us, and particularly when you ask about differentiation, you look at impact rather than language. And a policy may differentiate on the grounds of race, either because it does so expressly, or because it does so in its, or because it has a differential impact, even if it doesn't do so expressly. Or thirdly, because it might, in its application, in its administration, be differentially applied to people of different races. So that you really get three forms of differentiation. The one would be explicit, where it's on its face differentiates. The second would be where it differentiates in its impact, with the policy itself differentiates in its impact. The third is where the application of the policy might be sound, but if it is applied in a manner which impacts adversely on one group and on another, then that would also constitute discrimination.
Mr. Trengov, can I ask you about intention? So we have had submissions which say we have no intention to discriminate. Is intention relevant? If so, what is the relevance of intention?
Let me say this, Chair. Intention is irrelevant to the determination of whether there is race discrimination. Discrimination on the grounds of race. Intention may become relevant at two levels. The first is in the fairness inquiry. It may sometimes be relevant to say that my purpose with this policy is X. It is not intended to discriminate. And I accept that it is an incident of the policy that there is discrimination, but that's not my purpose. It doesn't remove the policy from the category of race discrimination, but it may sometimes be relevant to fairness. For instance, if there is no other way of doing it and if the adverse impact is slight, but it's merely a factor that goes into the fairness assessment. It doesn't absolve the perpetrator at all. Fairness may also, and fairness may secondly be relevant at a different level, and that's this. Remember that once you've concluded that somebody commits unfair race discrimination, then it is not yet a crime in itself. It just means that that conduct is unlawful, unconstitutional, and may open the perpetrator to the remedies, the penalties provided for under the Equality Act. In the determination of the remedy, i.e. the penalty to be imposed, intention may again be a relevant factor, because it is obviously, there is obviously greater culpability where race discrimination is perpetrated intentionally than there would be if it is unintentional. So,
Can I also ask another question related to the issue of intention? Let us assume that the outcomes that are produced by the application of a policy disproportionately negatively affect blacks as a fact. Assume that as a fact.
Yeah.
But you, as the administrator of that policy, are essentially reckless, or you do not care, or are negligent about that outcome.
Yeah.
What does the Section 9 say should happen in those instances? I mean, would that be evidence of discrimination, and if so, which type, direct or indirect?
Well, again, the analysis would be there is differentiation on the grounds of race. It triggers a conclusion that it is discrimination. It opens the inquiry into fairness. And in that inquiry, if the perpetrator has to discharge the onus of proving fairness, I find it very hard to imagine any circumstances in which it will succeed in discharging that onus if the adverse impact is a product of its own recklessness or its own negligence. You know, it seems to me almost a foregone conclusion that where the disproportionate impact is the product of the perpetrator's negligence or recklessness, then the conclusion would be that it's unfair.
And that would be based on an objective standard, an objective test.
Oh, yes,
So
absolutely.
it doesn't matter what the subjective intention of the perpetrator was.
Yeah, you may conclude that the perpetrator was subjectively negligent or reckless, and for that reason you would conclude that the conduct in question is not fair, because although it might not have intended to discriminate on the grounds of race, the discrimination was caused by its recklessness or its disregard of that risk, and then you would almost inevitably conclude that it is not fair. Could I take you to two paragraphs of the same Walker judgment on the question of intention? The first is at paragraph 39. Where the court said the following: With regard to the question whether intention has any relevance in the determination of unfairness, it is to be noted that in none of the 4 judgments was it suggested that intention to discriminate is an essential element of unfair discrimination. In other words, it's not a requirement, intention is not required in order to render the discrimination unfair. People can inadvertently perpetrate discrimination, which is unfair, despite the fact that they didn't intend to do so. And then at paragraph 43, if I can pick it up just after footnote 40, in many cases, particularly those in which indirect discrimination is alleged, the protective purpose would be defeated if the persons complaining of discrimination had to prove not only that they were unfairly discriminated against, but also that the unfair discrimination was intended. This problem would be particularly acute in cases of indirect discrimination, where there is almost always some purpose other than the discriminatory purpose involved in the conduct or action to which objection is taken. There is nothing in the language of Section 8.2 which necessarily calls for the section to be interpreted as requiring proof of intention to discriminate as a threshold requirement for either direct or indirect discrimination. Consistent with the purposive approach that this Court has adopted to the interpretation of provisions of the Bill of Rights, I would hold that proof of such an intention is not required in order to establish that the conduct complained of infringes Section 8.2. Both elements, discrimination and unfairness, must be determined objectively in the light of the facts of each particular case. So intention is not a requirement. The absence of intention may be a factor, but it is not a requirement for. So if I could then go lastly to the Equality Act, of which I've also annexed an extract to the papers I've handed up to you. It seems to me that the provisions relevant to our discussion is firstly the definition of discrimination in Section 1. It says, discrimination means any act or omission, including a policy, that's our policy we're talking about, a policy, law, rule, practice, condition, or situation, which directly or indirectly, there's again the directly or indirectly phrase, imposes burdens, obligations, or disadvantages, or withholds benefits, opportunities, or advantages from any person on one or more of the prohibited grounds. So you'll see that it's direct or indirect, and there's no requirement of intention. It doesn't say that it is done with the intention to discriminate. The prohibited grounds are again defined, and they include race. And then sections 6 and 7 prohibit unfair race discrimination. Section 6 is a general prohibition of all unfair discrimination. But then you'll see that there are certain forms of discrimination which have been afforded special treatment, the big three, as it were. And they are race, gender, and disability. The specific race prohibition of race discrimination is in Section 7. Subject to Section 6, no person may unfairly discriminate against any person on the ground of race. That would trigger again the Harksen analysis. Is there differentiation? Is it on the grounds of race? If so, it is discrimination. The last question is it unfair? Where the burden is borne by the perpetrator. In Section 13, there's regulation of the burden of proof in a manner which I would suggest to you is consistent with the Harksen analysis. Section 16 starts off by saying, 1, if the complainant makes out a prima facie case of discrimination, remember now this is discrimination as defined, and that is differentiation on a specified ground. A prima facie case of discrimination, not proof. The respondent must prove on the facts before the court that the discrimination did not take place as alleged, or the respondent must prove that the conduct is not based on one or more of the prohibited grounds. So what it does is it goes to Harksen. You'll remember the first two questions under Harksen is there differentiation? Secondly, is it on a prohibited ground? Now, in this, what this provision does is to provide us a leg up to the complainant, to the victim, in that the victim merely needs to prove those two, victim merely needs to answer those two questions on a prima facie basis. Prima facie evidence that there is differentiation, and prima facie evidence that it is on the grounds of race. Once that is, so that is what the victim needs to do in order to get a foot in the door. What then happens described in subsection 2. If the discrimination did take place on a ground in paragraph A of the definition of prohibited grounds, then it is unfair unless the respondent proves the discrimination is fair. So, under the first leg, the onus is on the respondent to prove that there is no differentiation or it's not on the grounds of race. If the respondent fails, in other words, if there is differentiation and it is on the grounds of race, then the respondent bears the onus which it has under Harksen of proving that that it is not unfair. It's presumed to be unfair unless it is proven not to be so. And section 14 then goes on to say how the inquiry into unfairness must be undertaken, what the relevant factors are when one assesses unfairness. And again, they're interesting and they're helpful, but there's no point in my reading them out to you. They will ultimately assist in any assessment, but they will almost never provide a mechanical answer. It is always a value judgment that you have to make at the end of the day. And the big question in that value judgment is what is the function of this policy? What is the purpose and function of it? The legitimate purpose and function of it? And does it justify the adverse impact on its victims? Emphasis at the end of the day is, question at the end of the day is the adverse impact on the victims, is it fair or not? So Chair, that's the outline, as I see it, of the law on unfair discrimination on the grounds of race. And I have nothing further to add to it.
Mr. Trengler, may I just ask on the meaning of section 14 and I suppose the determination of fairness or unfairness? One of the factors listed there is whether the discrimination is systemic in nature, which seems opposite to this inquiry.
Yes.
And I was wondering if you could comment on that and the importance of that.
Oh yes, because, and I don't think there's any magic to it, but what it suggests is that systemic discrimination is a far more serious issue than incidental discrimination. Because systemic discrimination, by its very nature, discriminates day in and day out against all the members of the disadvantaged class, and therefore requires, is therefore a more serious form of discrimination than incidental discrimination, and requires more serious remedy. So it is an important factor, but like all factors, not decisive in itself.
May I ask you about your reference to the, I think it was the Walker decision, the impact on geography. So assuming that you have a neutral policy ex facie neutral.
Yeah.
But on application, it disproportionately impacts people residing within a particular area. So both the policy is neutral and the impact is geographic rather than explicitly racial. How should we deal with that scenario?
If the impact is geographic and nothing more, in other words, it impacts on Harksen and not on Westcliff, and there's no other, in other words, there's no hidden enumerated differentiation in that differentiation, then it is not differentiation on an enumerated ground and also not on an analogous ground because it doesn't impair the dignity of anybody. But I assume, what is very important to my answer, is that I assume that there is no, for instance, no race difference between those two geographic areas. If the one is Alexandra and the other one is Houghton, then it's race discrimination by another name.
So if the impact is, people have been using various codes. One of them is socioeconomic status.
Yeah.
If the impact is felt disproportionately in, let us say, medical practitioners practicing in townships and in outlying areas, that could constitute racial discrimination.
Oh, yeah. Oh, yes. No, absolutely. I mean, that comes very close to Walker's case. Different rules apply to Waterkloof and to Atteridgeville. There's no mention of race. But if you come from Pretoria, as I do, then you know that that's code for race. Waterkloof is white and Atteridgeville is black.
And that's an example where geography and race intersect.
Yes.
But socioeconomic status and race could intersect as well.
Very much so.
So if it falls more heavily, the policy on new entrants to the profession, medical profession, and poorer, smaller practices.
Advocate Hassim, let me just make quite clear. I have confined myself to race discrimination. But of course, race is not the only enumerated ground. There are a whole long list of enumerated grounds, and socioeconomic status is one of them. So that may in itself constitute unlawful discrimination, not on the grounds of race, but socioeconomic status. Sometimes discrimination on the grounds of socioeconomic status may also be discrimination on the grounds of race, etc., etc.
I mean, I'm also interested in this issue because of intersectionality. I mean, assuming your inquiry, like ours, is focused only on race, the question, I suppose, is whether or not socioeconomic status can be a proxy for race.
Yes, I'm sure it often is. If you look at crime statistics, I don't know what the crime statistics say, but assuming in our society they say that more crimes are committed, a disproportionate number of crimes are committed by black people rather than white, then my suggestion would be that it's a function of a socioeconomic differentiation, that crimes are generally committed, or a lot of crimes are often committed by poor people and not, crimes are committed by poor people of any race, but if you have a greater proportion of black people who are poor, then they will also be disproportionately represented in that population.
Yeah, you may. Can I ask you also a general question, Mr. Trangov, on this issue? Because you see, let us assume, and not to get too much into the facts of what we're dealing with here, let us assume that you have a general population of medical doctors. So that's your 100%, 60% of whom are white and 40% of whom are black. And let us assume that black includes Indians and Coloureds. But in practice, when it comes to investigations under Section 59, 70% of those investigated are blacks, and less than 10% of those investigated are whites. Now you see there's an inverse between your potential target group and your actually investigated group. I mean, is that evidence of prima facie race discrimination? How should we approach that issue?
Well, let me go back to Harksen. there is differentiation because it differentiates in its impact. There's greater differentiation on some than others. Second question, that line of differentiation runs along the lines of race. So having concluded that there is differentiation along the lines of race, the third step is triggered, which means the differentiation constitutes discrimination on the grounds of race. The only remaining question then is it unfair? And in that inquiry, if you want to formulate it accurately, the real question is, has it been shown not to be unfair? Because it is the perpetrator who bears the onus of proving fairness. So yes, the facts that the hypothetical facts you raise will give rise to a presumption of unlawful race discrimination unless the schemes satisfy you that the differentiation is not unfair.
Mr. Prim,
Let me also just say that like in my robbery crime, there isn't necessarily a suggestion of unfairness, but there's a question of unfairness, and the onus of proof is on the perpetrator.
look, I was going to ask you a very similar question to the chair, and on the basis of a slide that is before you. But I want to say the following, that we have not heard from the schemes or the funders, administrators yet. We've only heard from the complainants thus far and certain representative associations. But we are getting evidence from those associations about a disproportionate impact. So this slide is not, we're not suggesting that this is a matter of fact, the figures in this slide. But if you look at the slide, which refers to psychiatrists, and it's based on the members of this organization of psychiatrists. And if you look at the first row, it tells you how many members they have and how that's broken down by race. 64 black, 6 colored, 66 Indian, 147 white.
That's the population.
That's the population.
By race.
So, that's right. And then at the very last line, well, actually not the very last line, let's start at the third. The number of members investigated. Or even the second, number of investigations per race category. We start to see that there's a greater proportion of black psychiatrists than white, and we see that reflected in the percentage in the last line. So 35.9% black versus 17, well, black, if you take all three categories, it's even greater if you put them together, versus white. So this is an example of what we've just been discussing with you now, which would need to then be put to the funders to disprove that this is unfair discrimination.
Yeah. Taking these figures as hypothetical, on their face, they clearly say two things. Firstly, there's the disproportionate impact, and that the line of that disproportion runs along the lines of race. It means that it constitutes discrimination, and it raises the fairness question, where the funders would then have to satisfy you, bear the onus of proving that the discrimination is not unfair.
Mr. Tringo, I have one further question. In Harksen and in Pretoria City Council versus Walker, you had one complainant. In inquiries such as these, there are many, and there are many potential complainants. Is the test designed to cater for both situations? Yes,
because remember, Mr. Walker was typical of his kind there, so he was also just the personification of a very large class who, if he had a complaint, would have had a complaint too. So the Walker test would still apply, and one would then simply allow for the fact that the impact of the discrimination is felt by many and not by one alone. But it seems to me that that is a relevant factor, whether the party before you is Mr. Walker on his own or Mr. Walker and the rest of White Pretoria. The question still is it unfair to White Pretoria to have the policy that they adopted, regardless of who the person is that raised the complaint before you? So I don't think that the number of complaints in the forum makes any difference. You ask yourself how many people are victims, whether they're here or not.
I was just interested in the earlier question in relation to just making sure that there's clarity when you say those figures do give rise to the inference of discrimination, that
Yes.
that is not unlawful per se, because it's only unlawful if it is unfair.
Yeah. Remember, you're quite right, and the language you use is right as well. The prohibition is a prohibition of unfair discrimination. Questions 1 and 2 leads to a conclusion of discrimination, presumed to be unfair, but not yet shown to be unfair or shown to be fair.
Now, I just want to go back to this issue. So we've spoken about intention, and we've spoken about the possibility of recklessness. But just to make sure that I understand the correct legal position. So you have a neutral methodology for conducting investigation that constantly over time produces racially skewed results. And let us say that the method is neutral, but the results are racially skewed, and that you do nothing about it. Can you draw an inference of discrimination from the failure to do something about racially biased outcomes produced by the application of apparently neutral methodologies?
The answer is yes, but I think the answer is actually easier than the question suggests. Because remember, if you go back to the rule that it is for the perpetrator to satisfy you that the discrimination is fair, then you will simply not credit the explanation if it is the product of inadequate regulation. Or there may also be in such an inquiry a difference between the forward-looking inquiry and the backward-looking inquiry. And I'm now going to speak hypothetically again, because I really don't know the circumstances of your investigating. But assume that there is a perpetrator whose policy is shown to impact disproportionately on black people. So there's an inquiry into, the conclusion is discrimination. The inquiry is one of fairness, and the perpetrator has to prove. Now the perpetrator says, my goodness, I'm so sorry, I never realized that my policy had that effect. That's not a complete answer, but it might persuade you, together with all the other factors and the slight impact that it has and so on, it might persuade you that the assessment of that policy on the looking back on the historical assessment is not unfair. But Mr. Perpetrator now knows that that is the impact of the policy. So going forward, Mr. Perpetrator would not have the excuse of ignorance of the impact of its policy. So it would be quite rational for you in such a case to conclude, I conclude that your historical conduct has not been unfair, but now that the racially discriminatory impact of your policy has been shown to you, it would constitute unfair discrimination for you to continue to apply this policy as you have done in the past, because it is a flawed policy.
Can I challenge you on that to say that wouldn't it be more appropriate to say that it's relevant to remedy rather than to whether there's rather than fairness. So the response that says, I had no idea, wouldn't change anything as far as the unfairness or fairness leg of the inquiry goes. It really is only relevant with regard to remedies.
You are quite right in saying that it is not decisive. In other words, ignorance is not an excuse in itself. But ignorance is also not irrelevant. If the perpetrator genuinely didn't know and couldn't have known, and if there is no suggestion that he should have investigated the matter, in other words, that you can't say of him that he should have known, then ignorance may well persuade you that his past conduct was not unfair. So I do think that ignorance is relevant to the fairness inquiry, not decisive by any means. It's not an excuse, but it is a relevant factor. Looking back, looking forward, of course, there's no longer any ignorance. So.
But you see, let's just take this one step, this inquiry with my colleague now. So let's take Medical Scheme X, the hypothetical Medical Scheme X. Yeah. It conducts Section 59 investigations in 2016. Yeah. They show by far that disproportionately the impact is on black doctors as opposed to white doctors, despite its population size. Yeah. In 2017, they do nothing about it, they continue. Yeah. In 2018, they do nothing, they continue until this investigation. Yeah. So there is both the previous and the future conduct. Yeah. Is that conduct relevant to remedy only, or is it also relevant to, I think that's the point that Ms. Hassim is trying to inquire.
No, but the fact you postulate is someone who was not ignorant. They knew that their policy impacted disproportionately on black people and did nothing about it. Intention is relevant to fairness. And in the same way as I've said, an innocent mind is not an excuse, but it's a relevant factor. A guilty mind is, by the same token, also a relevant factor. It increases the burden of proving fairness, and it's very hard to imagine that knowing and deliberate discrimination can ever be justified as fair.
May I ask a related but slightly different question? Just hypothetically in relation to the claim of ignorance, not knowing, for example, the disproportionate impact on black people, how can that be credible when you can see that people are black or white, where race is visible to the eye? You must forgive me for not knowing the facts of your case. I'm talking about a hypothetical...
It's the facts of our inquiry, Mr. Trengov.
Yeah. No, I appreciate that. But I'm talking about a hypothetical perpetrator who does not realize the implications of its policy. If you tell me that in the policy that you're looking at, people do know what the implications of their policy are, then of course that is a different matter. But that's a question of fact, not a question of law.
Yes. I mean, I suppose what you are suggesting to us is that the inquiry is actually a simple inquiry, and we may be overcomplicating it because we have to look at whether the outcomes are disproportionate to a population group. Once we are there, discrimination is established. What is presumed is a question of fairness, which then requires justification by the perpetrator. Yeah,
and it means that if you are left unable to determine whether it's fair, then the perpetrator loses because it bears the onus.
Thank you, Mr. Trengov. We are very grateful that you've taken the time to prepare and to come and present.
It's been a pleasure. Thank you very much.
All right, so the inquiry will be adjourned until, I think we have one more presentation, I think until 3. Until 3.